It's such a pleasure to be joining you right here on ET Now. I'm Supriya Shrinate and this is the India Development Debate. Now, call it a new twist to the murky bad loan saga. The Central Information Commission has issued a show-cause notice to the Reserve Bank of India, accusing the RBI of hiding names of high-profile loan defaulters. The CIC has said that the central bank must adhere to a Supreme Court order mandating disclosure of names. It has also shot off scathing letters to the Prime Minister's office and Ministry of Finance, asking details of action taken after a letter on loan defaults was written by former RBI Governor Raghuram Rajan when he was in office. Why has the RBI kept defaulters list secret? What could be the impact of naming and shaming? To answer all of that and a lot more, we're going to discuss precisely this topic on the India Development Debate. Joining us, a very special panel. Mr. Wajahat Habibullah, former Chief Information Commissioner, joins us. Mr. R. Gopalan, former Secretary in the Department of Economic Affairs and, of course, India's former Finance Secretary, and somebody who's also been on the board of the RBI. Pradeep Chaudhary, former Chairman SBI, joins us, and Bishwajit Bhattacharya, former Additional Solicitor General, joins us. And, of course, spearheading this discussion with all of us here will be our consulting editor, Maithili Pusnurmat. So, thank you very, very much, all of you, for joining us. Really appreciate your time. And this one's turning out to be a big controversy. Maithili, if I may ask you, and I remember we having this chat earlier today, there is suspicion that you raise as far as the timing of the CIC letter is concerned. Why do you believe this timing is suspicious? I know it's come 3 years too late after 2015. I mean, why was the CIC quiet all along? But why do you raise suspicions on the timing of this show cause notice issued by the CIC?
Well, yes. Yes, Supriya, the timing is certainly suspect because the CIC is, raising a reference to the Supreme Court judgment of December 2015. And subsequently, in fact, in November 2016, the Supreme Court, a larger bench headed by the Chief Justice, in fact, had said, and let me just quote over here, it said, disclosure of the names will not lead us anywhere. The root of the problem is why are these NPAs accumulating? Why are they being allowed to do so? And in fact, the court asked for a committee to be set up to go into the issues, and the Reserve Bank of India had actually submitted a list of the defaulters in a sealed cover to the Supreme Court. So, to my mind, it sounds suspiciously as if it's part of the continuing spat between the Reserve Bank of India and the government. Otherwise, why would the CIC now raise the issue of a Supreme Court judgment in December 2015, which has subsequently, if not been completely overruled, has been overtaken by a larger bench which is still hearing the case? To my mind, it doesn't do the CIC any good at all, and this is a matter which I think the RBI has explained to the Supreme Court earlier, that they are protected under Section 45D and E of the Reserve Bank Act and Section 8(1) of the RTI Act. So, the timing really doesn't do the CIC any good at all, in my view.
Okay, just hold that thought, because I've got India's Chief Information Commissioner, Mr. Wajahat Habibullah, also joining us right here on ET Now. And thank you very much, sir, for sparing time out and speaking to us. This is turning out to be a bigger controversy than any of us had imagined. First, the RBI versus the government, now the CIC issuing this show cause notice. There are many, and I think Maithili represents a large section of those who have raised questions on timing of this show cause notice being issued, who believe that, this has been very half-baked. And if I can just point out facts, 2015 September is when a two-judge bench had given an interim order. November 2016, a larger bench did give. That's when the CIC bench had said that since SC is already hearing the case in May 2017, we are not going to give a final word on this. Why do you believe the CIC has acted now, and in some sense, have they jumped the gun?
Well, you will have to ask the CIC why they're acting now. I am not, as you said, I was Chief Information Commissioner many years ago. I was indeed the one who was the first in India, but I am not Chief Information Commissioner now, so I cannot answer that point for you. But the fact is that if information is disclosable, the Central Information Commission has so decided, then the information is disclosable. It's no use arguing that this section says this and that section says the other. We are not the competent authority. The competent authority is the Central Information Commission. Now, if you are not satisfied with the decision of the Central Information Commission, there is a whole process of actually appealing that, and the appeal lies in a writ petition before the High Court. So take recourse to that. Do not necessarily try and set aside or demean a judgment of the supreme quasi-judicial authority under the Right to Information Act in the media. The question is whether it's suspicious or not suspicious. These are thoughts that can be entertained regarding any decision taken regarding anything. The point is, if it is suspect and if it is not satisfactory to any of the parties involved, the matter must lie in a PIL before the High Court.
Fair point indeed. Let me just quickly take this across to Mr. R. Gopalan before I move any further, and as himself being a former bureaucrat, also served on the RBI board. The RBI has of course gone behind and said that this information has not been disclosed because large value cases of frauds are under various stages of investigation. Minutes of action taken report contains confidential information about third parties, and wouldn't the question then is that wouldn't this impede the process of investigation? But before I get to the moot question on, you know, does this endanger investigation, which I'm going to take up with Mr. Pradeep Chaudhary in many ways, to you, Mr. Gopalan, which side of this camp are you? Are you someone who, like Maithili, believes that, you know, the CIC's questioning itself is questionable, or are you in the camp of Mr. Wajahat Habibullah, who believes, you know, it is their domain, they've done so, and if you don't agree, you have recourse, you have legal recourse, but to question their timing is not going to do anybody a world of good. Which camp are you in?
Well, I won't call myself to be in any one of these camps. Let me explain why. Legally, RBI Act 45E(3) says, notwithstanding anything contained in any law for the time being in force, no court, tribunal or any authority shall compel the bank or any banking company to produce or give information of statement whatever, that it follows from the various sections. Now, if CIC under its CIC law act, if it forces RBI to make the banks to give information, then it, in my opinion, it may fall foul of this particular section. But once again, for if CIC has passed a law, because Central Information Commission has the ability to pass law on providing information, and if RBI is not satisfied, it goes to the appellate authority, which is High Court and Supreme Court. Now, as Maithili says, or you say, it is now pending before the Supreme Court before any final decision is yet to be taken. So, when legally, if you look at the sequence of events that have taken place in the last 3-4 years, now if the matter is still pending in the Supreme Court, no final decision has yet been taken by the Supreme Court, I am just wondering what made the CIC to issue this show cause notice. But there are certain practical things which I can explain. You explained about investigations getting jeopardized by providing this information halfway through. There are other side to this information also. I will reserve my comment as we go along.
Sure.
For the time being, I will leave it for others to comment.
No, fair point indeed, and I will come to you in just a bit on all of that. But Mr. Biswajit Bhattacharya, my question really is that yes, while the show cause notice has been issued to the RBI, and I know questions have been raised on the PMO and the Finance Ministry as well, where does the buck on disclosing these names stop? I mean, the RBI, in its rightful mind, in 2015 sent a letter or a list of names to the PMO. Apparently, the PMO didn't act on those, and now it's becoming a bigger controversy. I mean, is RBI being made the fall guy here? Because the domain of, you know, putting out those names in the public domain also rests as much with the government of the day. Mr. Bhattacharya.
You see, there are two things. The number one, the show cause notice issued to the RBI governor defies all laws. Central Information Commissioner treats the RBI governor as a deemed public information officer. There is no such concept of deemed public information officer. Number two, now public information officer, in fact, I would respectfully agree with Shri Wajahat Habibullah. Central Information Commission in its own wisdom has decided to pass an order, but this order is flawed ab initio because of the point which I mentioned just now. Number two, the judgment of two-judge bench of the Supreme Court of 16th of December 2015. See, there were 21 parties involved in that Reserve Bank of India versus Jayantilal Mistry, etc. I mean, that judgment was in the context of specific facts placed before the court. Now, for the Central Information Commission to say today that it has defied the order which was pronounced 3 years back is also a little extraordinary. I won't use the word suspicious, but it is surely extraordinary. Now, the third point which I would say, now today in India, the time has come, as my distinguished panelists very rightly pointed out, the section 45E etc. of the RBI Act and all, there are certain restrictions which have been imposed on the banks and financial institutions from disclosing, banker customer relationship, etc., etc., etc. So, until and unless those statutory modifications are carried out, this kind of a blanket order, you do this, you do that, I am directing the Prime Minister's office, I am directing the RBI governor, I am directing the finance ministry, I don't think in the long run this kind of an order will be sustainable legally should an aggrieved party take recourse to the writ jurisdiction under Article 226. Of course, in my view, the law should change. There should be a metamorphosis. Time has come not to give any shield of protection to willful defaulters.
All right.
But
Mr.
there is one very, very serious issue involved here. Who is a willful defaulter?
Okay, Mr. Biswajit Bhattacharya, hold that thought there, because I have to go around the table and I will come back to you. And I do have that question, willful defaulter versus a non-willful defaulter. And Mr. Chaudhary, coming to you, sir, I'm sorry you had to be patient and listen to all of us first, but coming to you first, the question really is that the RBI has chosen to not disclose the names on account of two facts. They first say that there are large value cases of frauds under investigation, and if any sensitive information from there is leaked, then it is going to impede the process of investigation. Is that a valid argument that the RBI is giving? That's question number one. And I think question number two also is, what does this tell us about what can or cannot be told? I mean, banking or finance somehow is sensitive. There is just about so much information that you can put out in the public domain. But let's first begin with the question. Is the RBI giving a good enough reason to not put out those names in the public domain?
I think you are looking at the cup as full or empty. It is, I think, half full. The thing is that it is not that the entire information is withheld. First, I will preface by saying that knowing RBI as I do, RBI would definitely not be defying any order, even implicitly, even stated or unstated, of Supreme Court. So, if this matter has gone to Supreme Court and Supreme Court is okay with this list not being public in the way some people would want it, I think the matter should rest there regarding the law. Now, regarding the naming and shaming issue, it is not that this information is not available to anybody. In fact, this information is available on RBI website on a need to know basis. If supposing some bank wants to give a loan to me, or if some company wants to appoint me a director, then that bank can make a query on RBI's website that whether I am appearing on the defaulter list or on a willful defaulter list. And only if they are satisfied that I am not on there, so they will open the account of the customer. So, it is not that this information is just a blackboard, there is nothing there. It is disclosed, but on a need to know basis. And I think what is being done presently is pretty okay, because any bank, any company any bank which wants to lend to a company can do a due diligence on its directors from the RBI website. And in fact, it has now been downstream to an organization called CIBIL. CIBIL is maintaining the willful defaulter list and the defaulter list, yes.
Okay, fair point indeed. But Maithili, I will ask you a very simple question, and just for the benefit of our viewers here, it's important to understand that not everybody who defaults on a loan is a willful defaulter. And for everybody who understands banking, you obviously know that. But for the viewers who don't follow banking so closely, a defaulter is not always a willful defaulter. You may not be paying the money back to the bank because of extraneous circumstances. Your businesses have failed, policies, decisions have, have gone against you. So not every defaulter is a willful defaulter. But if the matter is taken to court and if these, if these names are indeed revealed, that distinction between a willful defaulter and a defaulter really evaporates, does it not?
Well, yes, it's a very tricky and it's a very fine line between who is a willful defaulter and who is not. The normal way of defining a willful defaulter is somebody who had the capacity to pay and yet did not pay. But it always is a very fine line that you are drawing over there. And here Mr. Pradeep Chaudhary is entirely right that the information is available. In fact, the willful defaulter list is available, and once you decide to proceed against a willful defaulter, it becomes public knowledge because you're going to file a case in court. And here I'd just like to add a small clarification to what Mr. Habibullah said. The fact is that there is a writ petition before the Supreme Court. In fact, it's 573 of 2003, and the Supreme Court is seized of the matter. So it is not as if the judgment is over. The Supreme Court is still considering, and this is a 3-judge bench headed by the CJI or then CJI. So right now we really don't have any complete clarification on whether it should be disclosed or not. And it is also true that Section 45D does give to the Reserve Bank of India protection under law. So the question really is, does the right to information override the RBI Act or not? Number one. And number two, what purpose will be served by making the names public? As the Supreme Court said, it's more important to see what action is done. And I think there I rest my case, Supriya.
And I think that's a question that I also have for Mr. Habibullah. And Mr. Habibullah, the CIC's order comes on a plea filed by activist Sandeep Singh Jadau, if I've got his name right, Jadau, who asked for information on willful defaulters. In fact, his queries were very, very direct. He wanted to know the cases, the NPAs, the amount, what were the banks doing. So, this information on willful defaulters. My question, much like Maithili's, is whose purpose does it serve for these names to float around in the system? For a common man to know, whose purpose does it really serve is the big question. I know information is good. I know sunshine is the best disinfectant. But at a time when there is, as it is, so much of mistrust and there is this fear in any case, whose purpose does it serve to serve so much of information in the public domain on willful defaulters?
Well, first of all, let me clarify one other point also. Mr. Bhattacharya said that there is no provision in the law for a deemed PIO. That is not correct. I invite his attention to Section 5 of the law, which states that if a matter is referred to another officer, maybe the head of the department or the head of the organization, for giving the information, then that person becomes a deemed CPIO. But nevertheless, the point is that, as Maitriji says, the question of, she raised the question of Section 8.1. 8.1 is a question of economic interests. Now, it's a question of defining. Now, who defines? The person who defines is the Information Commission. Now, because there's a separate writ petition which is pending in a court on a separate case, then it does not mean that this case is now not to be taken in writ petition. That may be a ground. So there may be legal shortcomings in the decision of the Information Commission. That is to be appealed through a PIL, as I mentioned, not appealed through an appeal to a television channel. So the question is really that there is a decision by the legally constituted legal authority, quasi-judicial authority, to decide on an issue. They have decided on an issue. Now, if we have an objection to that, the matter has to go through the normal process of appeal. Whether it is in the public interest or not in the public interest, whether a purpose is served or not served, is not really material for the mind taking a decision on whether an information which is disclosable is to be disclosed or not to be disclosed, or in the first place whether the information is disclosable. And if a person is not satisfied with the decision of the Information Commission, the way out is not an appeal to a television channel, a way out is an appeal through a PIL.
Fair point indeed. I don't think we're trying to influence any decision here, but I think because it's the central bank in the dock, once again, it's only fair that we raise these questions. But to you, Mr. Gopalan, I think the larger point also is that what will it do to both lending and to recovery? Do you believe this could adversely end up impacting lending and recovery?
Well, in certain sensitive cases which are under investigation, it may have some impact if this information is disclosed. Certain information is disclosed, not all. Certain information cannot be disclosed. Certain information like the name of the person, how much he willfully defaulted, those kind of information is not going to affect an ongoing investigation. So, in that sense, that is in my view is totally okay. But once again, the point is that lot of information is available still. Okay. Now, banks publish a list of people who have not paid loans, put the photographs in the branches. In that sense, they are publishing information. So, that this information can also be in some sense kind of published. 2, there was a committee under banking secretary which recently held a meeting in which RBI also participated, in which they agreed that this list, those who are more than 50 crores of willful defaults, those names must be published. They agreed. RBI also part of this committee which made this recommendation. And thirdly, as Maithili says, this information is available in SARFAESI proceedings or in the DRT courts. These things are, information is available, somebody can collate it, it is possible to make it available. To the extent that the name of a willful defaulter, the amount he owes and to whom he owes, this kind of rudimentary information being made available, in my view, is not going to harm anybody in the system. That is a view which obviously is a practical solution, but once again this is something which people have to sit. There is a proceeding before the Supreme Court, there is a writ, there is still some confusion whether the writ is with respect to this particular issue or is it with respect to some other issue. There is some confusion, but if RBI is now aggrieved by this order, obviously they will have to go to the courts. Whatever is the appropriate authority, appropriate court they should go to, they should go to.
No, hold that thought, and I just to take the larger point forward with Mr. Prateep Chaudhary. Mr. Chaudhary, it's not just the names and the, it's the willful defaulters whose names are being sought. What is also being sought right now is the RBI's inspection reports and other things like that. To my mind, these are very complex technical things. It may not be very well understood by a public, and it may actually be misrepresented, misinterpreted by a lot of people. Do we run the risk of a run on bank? Do we, and in turn that having a catastrophic effect as far as the economic financial landscape is concerned? Is that a risk we run if we put out too much information in public, which is, remember, it is very nuanced information, because the general view of the public is everybody who hasn't defaulted is a, is a willful defaulter. He's a fraud. The reality is it's very nuanced, and it perhaps cannot be interpreted by people who have little or sometimes even no idea of banking. A run on banks, and imagine what it could do to the financial system.
No, I agree with you that this information has to be given, is to be compiled on a nuanced basis and should not be disclosed just in the public to everybody. But I think to conclude that this would lead to a run on the banks, I think would be a little far-fetched. Now, the thing is that if somebody wants to lend, now if first I will talk about the defaulter and willful defaulter. Willful defaulter broadly means that he has the money but he is not paying. Now, supposing there is a loss making business, the bank says you got the sale proceeds, you did not pay me. This chap says, no, I had to pay salaries, I had to pay some pressing creditors, I had to pay taxes, so I could not pay your interest and installment. So, both are right in their own way. So, therefore, I think there is a lot of circumspection that is exercised when somebody is to be put in the willful defaulter list. And in fact, at a certain level, the committee that is there, you have to give a notice to the company that on such and such date we will hear your case, please come with all the facts and with all your officials. And in case of public sector bank, that has to be attended from the bank side minimum by a ED, executive director, and for SBI it is one of the deputy managing directors and 2 other very senior officials, chief general managers, and those who are familiar with the case to take a call on willful default or not. Because if somebody is in the defaulter list and supposing he is a director in another company, the bank can sanction a loan to that company saying that defaulter list is pretty commonplace in commercial world. But if that company and that person is appearing on a willful defaulter list, there is no way a bank can extend any further financial assistance. So therefore, I think RBI has done it pretty nuanced, and there is also a provision for an appeal, because normally the customer or the borrower would be aggrieved. But I am saying that, you know, if somebody is appearing in the willful defaulter list, these potential lenders or his present lenders should know. Why must his neighbor also know? I don't know. So, but I think RBI would be pretty deferential to the judgment of the Supreme Court, and it is being examined at the highest level, the highest authority in the land.
I have a direct question, but I think Mr. Gopalan wanted to come in to make a point there. And one of the direct questions is, I understand the defaulter needs to know and his bank needs to know, but in some cases, a lot of people believe because, you know, when default happens and when banks take haircuts and when they need to be recapitalized, it is after all public money that is used. So what is this whole point of, you know, keeping it under secrecy, and will concealing or will putting it out in the public domain actually help the naming and shaming? Will it actually help willful default? Will it actually help arrest willful default? I mean, that's the counter argument to be made. And Mr. Gopalan, if you'd like to take that question, and I think you also wanted to make in a point there.
Yeah, I will make my point first, which is that borrowing from what Mr. Chowdhury said, there is a committee headed by executive director which examines, which invites the person to give the views, and there is an appeal provided. In some cases, even managing director of the bank also takes a call on these kind of issues, whether a person has to be declared as a willful defaulter. And willful defaulter is somebody who has the money, who has the ability to pay and did not pay, who has diverted the money which has which has given to the loan which he has taken from the bank, or he has misutilized the money, and he has the assets which are mortgaged under this particular loan he has disposed of without telling the bank. These are some of the conditions under which willful default is defined. Now, I think we are looking at willful default, we are not looking at default. So, defaults are, it can be for many reasons, we are looking at only at willful default. But coming to your main question of what it would be, I get the feeling that there is a belief, once again, if you are a willful defaulter, as Mr. Chowdhury says, you can't get further loans, you can't become on the board of directors of another company which SEBI will take care of. So, those kind of restrictions really creep in. So, based on these restrictions that are bound to come on the willful defaulters, naming and shaming will certainly be a disincentive to become a willful defaulter later. So, I have a feeling that this psychologically it acts on the person concerned, and I think it's a good thing to start with, provided you are able to give only minimal information of who is the defaulter, willful defaulter, what's the amount you defaulted, which company. The minimal information can be provided in the public domain without disclosing all the inspection reports and those kind of issues which you are talking of.
No, that's a point I want to discuss a little more. And Mr. Wajahat Habibullah, do you agree that, and just for the benefit of our viewers, it's important to put out data in public domain as well. Till March 2018, 28 economic offenders have actually fled the country, and many of them are defaulters. Do you agree that the naming and shaming and putting out data in public, and I might go with Mr. Gopalan, that put out restricted information, but putting it out in public domain and is perhaps going to add to the mounting public pressure that will force both the government's hand in cracking down on people who find it so easy to flee the country, and also on defaulters at large, willful defaulters at large, who will find it difficult to do so, and then make a mockery of our laws. Mr. Habibullah?
So you see what Mr. Gopalan has said, I would agree with entirely. In fact, I think the CIC order also refers to the question of willful defaulters. Now, when a defaulter has been established to be a willful defaulter, surely, as you rightly say, the public needs to know, and therefore this information should be voluntarily suo motu disclosed under section 41B. by the public authority, in this case the Reserve Bank of India. There's no question of protecting. Now, any part of that information which would, for the reasons that have been discussed already, which impede the process of investigation or lead to financial instability or harm the economic interests of the country, and so, that part can always be kept aside. The question now really is, and what is being debated, is a question of disclosure of the identities of willful defaulters. And I think on that, even among the discussion here, despite the differences of opinion, it's quite clear that most people agree that that should be disclosed. But I would again not go into the question of the merits of the decision, because that has obviously, or would have taken into consideration, all the manifestations and all the nuances.
Fair point indeed. I think Mr. Biswajit Bhattacharya wanted to come in to make a point. And after that, I'll take a quick breather, come back and discuss more. Mr. Bhattacharya, you wanted to come in?
Yes, please. I just wanted to make two sort of legal issues. Number one is that, under section 20 of the RTI Act, the penalty show cause notice which has been issued to the RBI governor, section 20 does not talk about deemed PIO at all. So, the liability of penalty only falls on PIO. So, this is a strict technicality which I am sort of utilizing and interpreting under section 20. So, that is why I said this notice will be ab initio void. Number two, Maithili raised a very, very important point, whether section 22 of the RTI Act basically overrides the section 45 of the RBI Act 1934. Now, may I just say the law is very clear. The later legislation, RTI Act is of 2005 or 6, always overrides the earlier legislation, and this has been decided by the Supreme Court in 1977, Supreme Court page 265. So, I am in agreement with the CIC's order that section 22 of the RTI Act overrides the other provisions of RBI Act, namely section 45, etc. But this has not yet been judicially tested.
We are already seeing a very strained relationship of sorts between New Delhi and CBI, New Delhi and RBI, CBI, yes, but we are really referring to RBI here. We are seeing an extremely restrained relationship between the government on one hand and our central bank on the other, so much so that people are now saying that will central banks pay a price for a populist government and all of that. But that apart, the reality really is that, there is already on the NPA, there is ED, there is CBI, there is government, there is RBI. Is the CIC getting involved in a very multi-agency, multi-pronged probe already, and is this going to muddy waters even further?
Supriya, the CIC does have a role, because after the RTI, the CIC has become a very important functionary. But I just want to add one very small clarification, that this discussion is really not about willful defaulters. It's about other defaulters. Allow me just here to quote the former Governor Raghuram Rajan. In April 2016, he made a statement. He said, "We have no problem if the intent is to publish a list of willful defaulters. But we believe that simply any act of default without understanding the severity of the issues involved, if it is just put out for the public to consume, it may create issues of loss of business as well of confidence, as well as create undue anxiety and panic, and therefore chill business activity." So, what is at stake is not the question of willful defaulters, which is everybody has agreed is in the public domain. The question is of those who are not necessarily willful defaulters. The RBI has an issue about disclosure only of those. And I'd also agree, just a small correction or clarification rather, with what Busri said. He's a seasoned lawyer. And though the later law does override the earlier law, so it will override the RBI Act, the fact is that even under RTI, section 8(1)(d) does give a provision for not disclosing something which is in the economic interest of the country. So, this would be construed as something that is in the economic interest of the country. So, here I feel it's important that the CIC, while it does ensure that the RTI is upheld, at this particular juncture, when it comes in and raises an issue about a much earlier decision of the Supreme Court, when there is a PIL in court, Mr. Habibullah. There is a PIL before the Supreme Court, and the CIC in May 2017 has not taken a decision precisely because it says let the Supreme Court first decide on the PIL and only then we will proceed. So I think at this juncture the CIC has needlessly muddied the waters.
Habibullah, I wanted to come to that because I know you have a point of view on this. Do you believe that in many ways, more than one, there are a lot of people who believe out there that this is in any case such a huge probe. It has obviously not just chilled business activity, it has completely led to a lot of collateral damage. In some sense, did CIC need to add more to this?
If I may clarify another point, since Mr. Bhattacharjee raised the issue on the question of Section 5, I would request him to have a look at Section 5, subsection 5, which says that any officer whose assistance has been sought for answering questions will be treated as a central public information officer, which will then, of course, also apply in terms of penalties that are to be imposed. But that is one question. The second question is really the question of whether this has complicated the issue or not complicated the issue. As I said, so far as the Information Commission is concerned, its job is not to go into the question of whether its pronouncements are going to complicate the issue or not complicate the issue, and therefore only disclose that which is not going to complicate the issue. The Information Commission's job is to see that information that is disclosable is disclosed. It's quite simple and straightforward as that. Yes, as Maitriji has pointed out, Section 8 does protect government from disclosing information under certain circumstances. Whether Section 8(1)(d) is actually applicable in this particular case or not is again a question for the Information Commission to decide, and a question for the person representing the Reserve Bank of India before the Information Commission to actually interpret for the Information Commission. If the Information Commission has taken a decision in the matter, then the matter is, as I said to you, the decision may be flawed. There are a lot of court judgments which are flawed, and there is a procedure for actually remedying that flaw. So that is all I'm suggesting.
Okay, fair point. Just hold that thought, and Mr. Gopalan, I want to come to you. The larger point being made here is, I don't want to get into the technicalities because I'm sure all of you are better informed and better placed to answer that. But if I may just take the discussion away from the RBI for a minute, and really the moot point of this discussion is a list of defaulters that was sent from the RBI in 2015 to the Prime Minister's office. The controversy there is it wasn't acted upon. What explains inaction? What explains the fact that this list was perhaps put on the back burner in the cold storage, not dealt with?
I have no idea, frankly, why until since Mr. Rajan disclosed, that was the time when we came to know, and still we do not know what is the set of, under what criteria he has chosen some names and sent across. We do not know. Probably he thinks that, these are cases in which some crimes are involved, probably they may have to be looked into in more detail, more vigorously and more rigorously. Probably he may have this view. I have no idea at all. So, until one gets to know exactly what is the rationale behind sending a list and what was the purpose of sending that list and what was requested of Prime Minister's office and the government to help the RBI and the banking system to do further activity on that, is something is not known. So, until the information is known, I do not think it will be appropriate for anybody to comment. Anybody can make comment on both sides. It may not be a very fair comment to make on this particular issue. But other issue relating to defaulters, as Maithili says, if defaulters list is to be published, and I do not think that is a very fair thing to do, because default can take place on many counts. Maybe economic downturn would be a reason for a default, maybe certain other aspects can be a reason for a default, and disclosing those kinds of information will not only jeopardize the revival of that particular default company from coming back into economic activity, which it will create chaos in the market. So, I get the feeling that if it is willful defaulter, yes. If it is only a defaulter, right, I think we have got to be circumspect about it. And as far as the Prime Minister's office list is concerned, I have made my point.
No, absolutely. You know, I just want to read a substantive part of the CIC order, and if I may come to you, Mr. Chaudhary, the Commission recommends the RBI Governor to remember once at least one of the 3 lakh farmers dying in the fields as he failed to sustain his crop or to sell his produce for appropriate price, and hence could not pay off the debt before denying the transparency law and directions. You know, the reality is that this is a CIC order. Why is it going into theatrics? This has to be completely legal. This has to be completely decided on merit. Why is it going into the theatrics of farmers dying or, you know, making an emotional appeal? A CIC order, and do you believe this is the risk we run? And that is the problem right now. The risk that we run is that a lot of people believe that there's something wrong with India's banking space, there's something murky, there's something shady, there's something not so transparent happening there. And these are things that, and you know, this whole narrative of we are saving the willful defaulters, but we're letting the farmers die. I mean, are we feeding into this narrative as agencies as well?
Yeah, there is a lot of media trial and public trial by this kind of thing that is going on. But you know, the thing is that today it is almost impossible for a person appearing in willful defaulter list to get fresh credit facility or even renew his existing credit facility. So if that is the objective, that you cut them off once bitten twice shy, once you think that these people have mishandled the money, then I think you can cut them off from the system for future. And that I think is happening to quite an effective extent. And even as I said, that if a company is a willful defaulter, all the directors are, you know, taken off, and they are also branded as willful defaulters, and it becomes difficult for them to continue in that operation, and the banks insist that they step down. But why CIC has done that, only I think CIC can explain. And but I think this is to be seen purely as an economic step, and whether it can prevent people from doing repeated defaults. So I think to that extent this objective has been adequately served. And let me tell you, willful default is never an open and shut case. There is a lot of contentious issues, and at the end of the day, the company or the borrower thinks that he has been unfairly treated, people have not understood the reality, and the bank thinks, oh, you took the money and he never repaid, so he cannot be anything but willful defaulter. But I think the truth lies somewhere in between. So there should be an attempt to discover that, but no matter what we do, it will remain a subjective proposition. So I think today what exists is an adequate framework, but however, the matter is before Supreme Court, and you know, superior judgment can.
No, absolutely. I couldn't agree more with you there, and I think that's a very nuanced, very balanced answer, and I appreciate the fact. But Maithili, just to take that point forward, that, you know, whatever may happen, this is going to lend itself to some subjective interpretation. The reality is that a week of RBI versus the government, the RBI is back in the dock again, and to my biggest surprise, you know, some of the most informed, learned people, the commentary coming from there is, why is RBI protecting willful defaulters? That's the narrative this is going to feed into. Am I wrong there?
Well, yes, it is very unfortunate, but I think just when we were thinking the hatchet had been buried, and both sides will sit down at the negotiating table or talk things over and try and find the common meeting ground and move ahead, because ultimately that's what the country needs. It's most unfortunate that these pot shots are being taken, and I do hope that I think all concerned will realize that this doesn't do anybody any good. So I think it's important that, you know, these are technical matters, leave it to the government and the experts and the Reserve Bank of India to sit down and find what is the way forward, rather than raising these issues, which, as I said, to talk about a judgment which came 3 years ago at this juncture, even if it was in the best of intentions, just doesn't go to, it's important that it, you know, appearances also matter. So just the timing looks a little odd. Questions will be asked, and that I think is a wrong thing to happen at this particular juncture, which is a very sensitive issue at the moment.
No, absolutely, and this almost gives you a sense of an implosion last week, unraveling this week. Where are we taking the whole economic narrative? Mr. Bhattacharya, I know you want to come in there, and I have a very direct question to ask of you. Now that the CIC's latest order is a show cause notice to the RBI has stuck to its position, saying that they cannot disclose names on account of everything that we've spoken about. I'm presuming the RBI is not going to play ball. So what happens next on this? How does this move on?
In my view, again 2 points. Maithili has stated that disclosing informations will be contrary to the economic interest. Well, a view may also be taken that non-disclosure will perhaps be worse. So, that is a matter of subjective interpretation. Ultimately, section 22 of the RTI Act 2006 will have to be given effect to, and it will have to be interpreted. The secondly, I would respectfully again differ with Honorable Wajahat Habibullah. Section 5 subclause 5 does not use the word deemed PIO, which the learned Central Information Commission has used. And if he seeks assistance from any officer who is a custodian of the records, now this PIO does not seek assistance from RBI governor. So therefore, on that count, it is my considered opinion that to use the word deemed PIO, which is alien to the RTI Act, even section 5 subclause 5, which Mr. Habibullah said does not use the word deemed. And when PIO seeks assistance, PIO does not seek assistance from RBI governor, he is the boss. RBI governor is not the custodian of the records for which information has been sought. So this entire show cause notice of levying penalty under section 20 of the RTI Act, in my view, is ab initio void. And ultimately, in India, the stage has come. We cannot keep anything under the carpet. Now, whether it is a willful defaulter or non-willful defaulter can be a subject matter of debate. It's a very sensitive issue. Nobody should be branded as a willful defaulter. Nobody.
No, I understand that. I know everything cannot be brushed under the carpet, and the time in India has come for, some such thing. But the reality also is that this is sensitive information. And while I know there may not be a run on the banks, but there could be misinterpretation of the data that may be available in the public domain. And I think to that point, I agree with Maithili, and I partly agree with Mr. Chaudhary there. You cannot risk any misinterpretation, misrepresentation here, because this is going to lead to fear. This is going to lead to panic. Mr. Wajahat Habibullah, a quick last word to you. And I think the reality also is, while, the CIC perhaps has done what it believes is the right thing to do, which is to put out information in the public domain that is being denied, but this information is being denied both by the PMO and the RBI. In some sense, by just serving a show cause notice to the RBI and rebuking the PMO and FinMin, is CIC doing just half a job?
Yes, just a brief on what Mr. Bhattacharya said. Mr. Bhattacharya, you're not going to vanquish me on the interpretation of the RTI Act. That is a strong point with me. No, treated as a Central Public Information Officer means exactly they will be deemed to be Central Public Information Officer. Seeking the assistance even means seeking the permission. Without his permission, you do not disclose. And there are many decisions that I have given in this of this nature, which have all been upheld by the court. So I don't think we need go into that in detail. But yes, the difficulty here is, the point here that I would wish to bring across is that the ambience should be one of transparency and accountability. The manner of dealing with this particular subject has contradicted that ambience, and that is what has caused this crisis. If there was generally the feeling and the reassurance given by the Reserve Bank of India and other organizations that information which is disclosable will be disclosed, not giving the impression that information which is disclosable is not being disclosed. That area, transparency and accountability which in fact the present government has been an election manifesto, has had in its election manifesto. In that case, this problem would not have arisen at all. And therefore, if this problem, if this you may call it misunderstanding persists, it becomes the duty of the Central Information Commission to ensure that this atmosphere does not exist and that access to information will always be there where access to information is legally sought.
Well, I completely back you on the point that access to information should be there, and a person cannot be denied information if it's rightfully information that can be disclosed, and any such attempt to block the Right to Information Act needs to be, pushed back, needs to be fought back. But the reality also is that I think this is going to be a nuanced issue. This is going to be subjective interpretation. Taking defaulters and willful defaulters, both their names to court is going to paint everybody with the same brush, and that may not entirely be true of people who default on loans. There are policies that go wrong, there are businesses that fail, and all of that is not on account of willful default or not on account of people who want to flee this country and escape the law. But on that note, thank you very, very much, each one of you, for being with us. Mr. Chaudhary, Mr. Gopalan, Mr. Wajahat Habibullah, and of course, Mr. Bhattacharya, along with Maithili Busnurmat, for sparing time out this evening and being with us on the India Development Debate. We take a quick breather. We are back with Top 10 at 10.